Hi, everyone. We are Group 1 for School Law, and we're going to present to you Chapter 1, Legal Framework Affecting Public Schools, and I'm Laura.
Hi guys, I'm Drew.
Hi, I'm Caitlin.
Okay, as Laura mentioned, we're going to be talking about legal framework affecting public schools. First part we're talking about is the Bill of Rights and the 14th Amendment. Bill of Rights represents the primary source of individual rights and freedoms under the U.S. Constitution. So essentially, everything that we live by on a daily basis, that's the Bill of Rights. The first 10 amendments of the Constitution are viewed as fundamental liberties of free people because they place restrictions on the government's power to intrude on the fundamental rights of all citizens. So if the nation abides by those 10 amendments, they're not able to intrude upon our own rights as citizens. So we get to live our daily lives still abiding by those 10 amendments, but we're not able, other people are not able to intrude upon our rights. These restrictions simply mean that the government cannot exercise certain powers in relationship to free people. And for example, the government cannot pass laws prohibiting the freedom of speech. So overall, the government can't take our right of freedom of speech away. Nowadays, in real life, people get upset when people are using that right of freedom of speech, and they get upset and disturbed by it. But that's something that we have as citizens of this nation. That it's something that we cannot be stripped of. The Constitution of the United States is the basic law of the land. It provides a framework of law in which orderly governmental processes operate. The Constitution thus becomes the primary source of law. So anything from public law, public situation to state to federal, everything's going to go back to what the Constitution says. And some situations might be stickier than others, but the Constitution is always going to be something that we always go back onto and rely on. All statutes enacted at the federal, state, and local levels, as well as the state constitutions and local regulations and ordinances, are subordinate to the Constitution. So, what does it mean by subordinate? It's everything is below the Constitution. Like I mentioned, everything relies back onto the Constitution. Federal Constitution is distinguishable in its provision to protect fundamental rights of all citizens of the United States. Inherent among these rights are those involving personal, property, and political freedoms. So essentially, what those mean, personal, property, and political freedoms, is that we're able to do what we like within certain guidelines. Although the Constitution does not make a reference to education, it does impact the operation and management of schools, particularly in respect to amendments which protect the individual rights of students, faculty, and staff.
Okay, state constitutions. Based on the 10th Amendment of the Federal Constitution, power is not delegated to the United States by the Constitution, nor prohibited by its states. The state constitutions represent the basic source of law for individual states and generally require legislative bodies to perform various functions, including establishing system of public education. They prescribe the funding and operations for public schools. The state constitutions may exceed coverage granted by federal constitution, but may not fail to meet the basic requirements. The statutes represent an active legislative branch of the government, and it's the most abundant source of law affecting our public schools, and it focuses on policy, rules, and regulations. The statutes represent the most effective meaning of developing new laws or changing any old laws that we may have. The state legislators grant local school boards the authority to adopt and enforce reasonable rules and regulations necessary for our schools' operation and management of schools. So court or case laws. Case law is generally reflected in judge-made or common law. And then common law consists of judgment, opinions, and decisions of courts adapting and enforcing proceeding usage and customs called precedents. So then the State Board of Education is an administration agency created by state and they determine the direction of the education in each state. Public schools are placed under the control of State Board of Education, and the state boards develop the policies involving health, safety, teacher's license requirements, graduation requirements, or any other kind of needs based on what the state feels is their education needs. And then our local school boards impact our education policy and the administration and supervision of public schools. Their role is to the formulation of school district policy, which must be consistent with statute. These policies may be accompanied by rules and regulations that provide the direction and operation of how the schools should go. The U.S. system of courts. The judicial system consists of federal and state courts. The organization of the courts at both levels is essential. They need to all have trial courts, intermediate courts of appeal, and of course, the highest court, the Supreme Court.
So that's where we start to get into our federal courts. Federal courts typically deal with cases involving federal or constitutional issues, so things that don't really have an easy yes or no, black or white answer. Questions, these would be referred to as federal questions, or cases in which the parties are residents of different states. So whether it's someone suing someone from a different state, or if someone is a resident of one state, but the illegal action or whatever action is bringing them into a court situation took place in a different state. This is referred to as diversity of citizenship. The federal court system includes district courts, appellate courts, and the Supreme Courts, or the Supreme Court. There are 95 federal district courts in the United States. There's at least one federal court in each state. There has to be. Larger states such as New York or California, they're going to have more federal courts just because they're dealing with higher population densities, so more issues that need to be addressed. They can have up to 4 federal courts. Federal courts usually hear cases between citizens of different states, as we previously mentioned, and cases involving litigation of federal statutes. Federal appellate courts are represented by circuit courts of appeal. There are 13 federal circuit courts, including 11 with geographic jurisdiction over a number of states and territories, one for the District of Columbia, so Washington, D.C., and another involves 3 specialized federal courts. The primary function of an appellate court is to review the proceedings of lower courts to determine if errors of law, as opposed to facts, were committed, such as procedural irregularities, constitutional misinterpretations, or inappropriate application of rules or evidence. So if in a lower level or residential level, there was a processing error, more than likely. State courts are a part of each state's judicial system. Every state has one, with the responsibility of hearing cases involving issues related to the state constitutional law, state statutes, and common law. This is where many of our educational cases are going to be heard and seen, as education, at least as of right now, is a state responsibility, and federal questions don't necessarily have to be asked as heavily. Courts of general jurisdiction. These are going to often be referred to as district or circuit courts that I've been mentioning previously. Their jurisdiction covers cases except those held for special courts. In many instances, I apologize. Decisions may be appealed from these courts to intermediate appellate courts or even to the state Supreme Court. Courts of special jurisdictions were established to hear legal disputes in special matter areas. They were generally referred to as trial courts with limited jurisdiction and may be called municipal, justice of the peace, probate, small claims, or traffic courts. Some more common terms for them. So intermediate appellate courts, they've emerged rather recently. In comparison to the court systems used in the United States, it would have been in the past 3 decades to hear appeals from trial courts or certain state agencies. Their primary role involves reviewing processings from trial courts to determine if substantive or procedural errors occurred in applying the law. Now we kind of tie back to our Supreme Court. Obviously, this is the highest court in our nation. Unlike lower courts, there is no appeal beyond the decision of this court. This is the top. If you don't like the decision that they reach, tough cookies, there's no one else to take it to. A Supreme Court ruling can only be overturned if there's an amendment to the federal Constitution. That's why you'll hear Supreme Court cases being referenced in legal matters because they're considered law. So the Supreme Court has 9 justices, including a Chief Justice, and this comprises the High Court. To avoid political infringement, they are appointed to life terms. So the president is going to appoint them, and once they're in there to life, for life. Cases reach the Supreme Court primarily in 2 ways: on appeal or by writ of, I'm going to try my best, certiorari. Tried my best there, guys. So the Supreme Court and their lex, currently there is, or ethics, I apologize. Currently, there's none. I'm assuming that's what that means to say. The U.S. Supreme Court justices, as public confidence in the judicial system, dictate the need for an ethical code that governs the conduct of the U.S. Supreme Court justices. On November 14th, 2023, justices announced that they will be embracing a code of ethics. However, it lacks accountability since there's no enforcement mechanism. So that really just kind of leaves it up to each other. But you would hope that if someone's serving on the Supreme Court, that they have a solid moral set of ethics.